going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Hopefully you guys are having a great night so far. We've got a good one. It's a good one. We're in Judge Simmons court. This is a city or no, that was a video that I did earlier today. We have, it's not a city ordinance, it's a lawsuit. I I just recorded a video about an hour ago and I started giving you the same intro that I just recorded for the last video I did. Yeah, welcome to life. Anyways, this one is a homeowner filing a lawsuit against a contractor. The homeowner does not have an attorney, the contractor does. It's really interesting. It's really interesting, and it's a little bit of a long one. We're going to be here for a little bit. The entire video is about an hour and 20 minutes. I'm going to play the entire thing. I will try to speak as little as possible, but knowing me, this hour and 20-minute video may go for, I don't know, like 16 hours. All right. You guys are awesome. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Let's see. 23-02133. I'm picking up your appearance.
Edwards 84 on behalf of Defendant County Plaintiff Simon Zane.
I'll cancel your appearance for the record. Okay.
Oh, real quick. Are you talking about Mac the Knife? Did he raid me? I didn't know he I didn't know he had a channel. But Mac raid. I don't know who specifically who you're talking about. So thank you. I did see this message earlier. Happened at 5:30. 2.5 hours ago. But yeah, I did set this live up really early today. I was stuck in the office of a local park for multiple hours, so I went ahead and set this live up. That's a story you guys don't need to hear. But Mac, thank you so much. I appreciate it. Good evening, Grizzly. Good to see you. All right, let's keep going.
Any prior?
Okay. Today's the date and time set for a bench trial. Are we ready to proceed on this matter?
Ready from
Heather.
You ready to proceed, sir?
Yes, ma'am.
Okay. Are you calling witnesses today, or are you giving testimony for yourself?
Testimony from myself.
Okay. Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. You can proceed to give your testimony about your claim.
Oh, I go first.
Yes, you're the
Okay.
plaintiff, so it's your burden.
All right. Well, back in 2022, in the beginning of the year, I began to plan to put a new roof on my home that I had just purchased at the end of 2021, and was looking around, called a few people, got some people to come out and give me some estimates, and I ended up going into a local party store close by my home, and it was owned by the defendant, and he had mentioned to me that he could do the roof for me. So because of my long-standing knowledge of who these people were and understanding that they've been in business for a lot of years, I don't know whether the construction part has been in business or auto sales or whatever.
Objection relevant, Your Honor.
I have history. I have history with.
So let me give you a little instruction. If there's an objection, you'll stop so that I can address the objection, okay? Relevance as to,
The nature and scope of the history of his knowledge of the relationship.
okay. I'm gonna overrule it and let him give his spiel.
That's what gave me the trust behind knowing that I would probably be okay using them, is the trust behind the knowing who they were. But I went ahead and told them, come over, give me an estimate. We came to an agreement that it'd be $6,500 labor if I went and bought all the materials. And so I had started buying materials. One of my first receipts was actually in, I believe, May and then August, and then again in November. I just was buying materials throughout the time of us connecting. Originally, he said it'd be a few weeks out, and this was in May when I had made my first original payment to him, which I have the documentation for all the payments that were sent to the defendant for the labor. The first time I made a payment, he had said it'd be a couple of weeks before I could get over onto my job. And then a couple of weeks go by, and I had gotten some communications between him and I, and he says, well, I've got a couple other projects. It'll be probably next month. And this happened throughout the summertime. And I wasn't in a huge rush, so I allowed it to happen because I was still going through buying materials anyways. I had stopped at a place that he referred me to, ABC Supply. I went in there to go purchase my stuff back in like June or July for the roof. And they said, well, actually, do you have a date in which it's going to be installed?
Objection, hearsay, Your Honor.
The objection sustained. So you can't tell me what someone else said.
Okay. They requested that I come back and purchase them.
Again, just continue that objection. Hearsay.
You changing it to requested and asked. It's semantics. It's still the same thing. You're trying to tell me what someone else said that's not present in court.
When I went to purchase the materials for the roof, the shingles, the actual shingles, that 80, however many bundles of shingles that I needed, 85 is I think what the exact number that I purchased. I was told that I needed to.
Objection. Hearsay.
Okay. So you can't tell me what you was told. You need, but apparently when you purchased, was there a requirement for you to?
There was a requirement for me
them.
to wait until.
You didn't let me finish my
Yes,
question.
I'm sorry.
So she has to take down a record. Anytime you talk over me, she can't make out what's being said. So I'm just trying to help you out here. When you went to purchase the shingles or the materials, did you have to give a date for when the service was going to begin?
I didn't know the date.
But the question is,
Yes.
that was okay. Is that what the information you're trying to tell me without giving me the hearsay?
Yes.
Okay, you can continue.
I didn't know the date in which I would need them delivered. And so I needed to tell them what date that was.
Okay.
And instructions were to pay the day before for the shingles. So I didn't pay until the day before. But
Well, you had to
nevertheless,
pay the
for
company
the
that
cost
you're
of the
buying.
shingles themselves, just the
Okay.
shingles. All the other materials, the plywood, the nails, the drip edge, the moisture, some of the moisture barrier that I had purchased, some roof venting, all of these things. In the very beginning, actually, I was given a register receipt list from their register at the party store saying, get this, get this, get this, and get this. And I took that list and I went down the list. I started buying the stuff and marking it off. The shingles were purchased a couple of days, like the day before the actual service was complete, when I knew an actual date they were coming. Throughout the process, I had paid him all the way up to $5,500 of the $6,500 prior to him.
The defendant $5,500.
Prior to him showing up, $5,500 total, all the way up until he showed up to the job. So I only owed him $1,000 balance. Upon the first day of service, I'm a service driver. I get on call, and so I have to leave and come back every day. That's what I do. Somebody gets a flat tire, I have to leave and come back. And so I had to leave home while they were there working. His crew was there working. And when I come home, I had noticed the first time I came home, within a few hours of them being there, that there was a piece of brand new plywood in the back of one of the person's personal pickup truck. And I knew it was my plywood because I had just bought it. And so I walked over to the truck and I lifted it up and looked under it, like there was debris on top of it, like old ripped off shingles that they were taking off. It didn't make much sense to me because there was a whole trailer sitting there for them to throw all the debris in. There's no reason for debris to go on personal vehicles. So I was like, why do you got this plywood in here? And I grabbed it out. As I was grabbing it out, I seen 8 bundles of shingles that were buried underneath all this debris in my brand new sheet of plywood. And so I made mention to it to the defendant in regards to the fact that some of my bundles of shingles that were just delivered for this project were now in the back of one of the contractor's trucks. And why was my shingles in the back of their truck? And I knew how many were delivered, so I counted them, and that many 8 bundles of shingles were off the pile next to the driveway. So I then got very leery of the whole project. and very scared as to what could happen next. So I quit doing work. I quit accepting jobs for 3 days and stayed home. I even made like breakfast for everybody and, you know, supplied like all kinds of hospitality, opened my home to them. They started ripping everything off, doing everything, getting everything going. And when they were ripping all the shingles off, not all the debris, but a lot of the debris was falling into my attic space, which was a very clean and usable space prior to this job. And so when they were ripping everything off, they put the new plywood on. They were going through and trying to skip some of the pieces of plywood and not tear everything off. And some of the pieces of plywood, the guy was the man's name was actually Diego. He kept saying, it's good, it's good, it's good. And I said, no, I got all new, all new. I kept trying to tell him all new. And I basically had to sit there and babysit the whole time and watch everything that was being done. Well, after a couple of days and everything was said to be done, I noticed that my back entryway still hadn't been shingled. And I mentioned it to Diego and he said to talk to the boss. And then I also went up into the attic because I wanted to start to do my insulation of the roof. And when I pulled down the retractable stairs in my upstairs hallway, I got half a dump truck full of debris dumped on me and in my face of all the rip-offs and some of the tear-off stuff that fell into the attic because when they tore everything off, it was falling down into there. I made mention to Simon. I said, can you please come? Because he was telling me the job was complete. I was like, well, that back entryway ain't done. The eaves troughs weren't put back up. And I still have this big mess in my attic. Can you please come clean this up and finish this up? And he demanded by text message that I pay him the $1,000 for the balance that he was owed before he come and finish cleaning anything up. Before he come and mentioned anything about the back entryway or the eaves troughs or anything, his text message to me every day was, can I get my money? When can I get my money? Calling, text. And I didn't even have a receipt or an invoice at this point. So I started telling him once I get a bill or an invoice or something.
Oh, I got it. I was debating whether or not to play that one tonight or this one, but I wanted to play this one because I told a few people that I would play this one tonight. I had a few messages that wanted me to play this one, so this is the one I chose tonight. But yeah, the Judge Simpson one is probably going to happen tomorrow night. And I'll play the whole case. OSG put a small clip of it out with when the victim came up and talked or spoke. But yeah, I will be playing the whole hearing tomorrow night, most likely, unless something wild happens tomorrow.
That proves to anybody in the world that I hired you, because we had no written contract, that until I get that invoice, there's nothing I'm going to do for any kind of a payment. So I'm going to need this invoice. And so within a few days of him finishing his job or a week or whatever, he sends me this invoice, this past due invoice, circled with red ink and past due on it, and adds $400 to the bill for dump fees taken to Granger. We had already agreed on a total price of $6,500. He's trying to add $400 for his trailer, not including the fact that I went up in the attic and did all the work myself. I had like 8 to 10 30 or 40 gallon contractor bags full of debris that I hauled out of my own attic by myself. And he's trying to increase that. So I didn't agree with that.
Did he include a receipt from Granger?
No. So when I went up in the attic to do the insulation and I got bombarded with all this debris and I get up in the attic, I start looking around and there's nails like Hellraiser everywhere. And
wait, there's nails where?
Coming through between the trusses in the attic. The trusses are where the framing nails are supposed to secure the plywood to the outside of the home through and into the trusses. Well, every which way you look, there's nails coming through that look like they were intended to hit the trusses, but did not. And so a lot of them you can walk right up to and wiggle and pull right through. And so these are all anchors that were meant.
Objection, foundation, personal knowledge, lacks personal knowledge, lacks the expertise, and potentially hearsay.
So there's some objections of how did you, essentially one of them is a lack of personal knowledge. The other one is you're trying to give testimony about something that you don't have a personal expertise in.
All right, and welcome to what this hearing is going to be. Now, this guy is unhappy with the work that was done to his home, and so he sued the contractor. Listen to what this guy says. I believe just about everything he says. The contractor has a lawyer, though he does not. It's unfortunate. It's unfortunate, but once you hear all the pieces to this, you're gonna feel bad for the homeowner. You really are. He should have got a lawyer. I mean, at the time, I mean, by the time he got a lawyer, though, I don't know if it would have been even worth suing this guy. Maybe he could have got all the money back. I don't know, but yeah, if you guys have ever been to an attic before, you always see nails coming through the ceiling. And yeah, I didn't know that that meant that the job wasn't done correctly. I didn't. You know, it just that's what you see. You just see the long nails from the shingles coming through the. Yeah, but it makes sense that those shouldn't be there. Anyways, let's keep going.
Are you able to address that? How do you know that, or what you were about to share? How do you know that that's the case?
I know that that's the case because in framing and structures, nails are used for one reason and one reason only.
I don't know what the amount is. I know he hasn't paid the full amount. He just said that a minute ago that he still owed him $1,000, but he was unhappy with the work, and so he wasn't paying him. And so maybe he's trying to sue him just to finish the work, or maybe to get all of his money back. I don't know. I don't know.
And that is to make an anchor or to connect two pieces of construction material together.
Okay, and so
And these are not.
you're saying, how do you know that though? Do you have personal experience with
I have,
building?
I mean, throughout my life, I have done all kinds of home repairs, and you can go online and look at some of the houses I've bought and flipped and sold and done all the work myself on them. 100% of the work. I mean, every bit of it.
You've done the work you're saying?
Absolutely, yeah.
So you do have some
I
experience
do
in
have
building?
tons of knowledge and experience of this. My father, when I was a little kid, my father was a contractor. I lived every summer on contract sites with my father building homes in Howell, $500,000 homes in Howell for years.
Okay.
So I have a
So
lot
based
of
on that
knowledge.
experience, when you view this, you believe you can make an assessment that
Absolutely.
of what you're saying?
Absolutely. Absolutely.
Have what,
You may.
Mr. Pryor, your deposition was taken prior to today's date, correct?
Yes,
You were put under oath at that deposition?
I was put under oath, or I was asked to.
You raised your right hand and swore to tell the truth. It's
Yeah,
very clear.
yeah.
You recall being placed under oath in that deposition?
Yeah.
All right, and you testified in that deposition truthfully, correct?
For the most part, yes, I believe I have.
I mean, did you lie?
About what?
I'm
The
asking you.
the question was, did you testify truthfully? Your response was
Yes.
for the most part. So that means, if I interpret
I
that, there were some
yes.
times that you weren't truthful. If
I mean-
that's your
He'll get to that. I think that question's actually asked. I believe it's asked, at least. Yeah, that's all I'll say. I'm fairly certain it's asked because I remember his answer to that question. So unless I made it up, he gets asked that question.
answer.
I-
So,
The truth can be depicted in three ways.
no, that's
I mean-
not, no, that's not the question. The question is if you testify truthfully.
Yes, I did testify truthfully. Yes.
Okay. Sir, do you recall being asked the question regarding your experiences in roofing?
In roofing or in
Yes.
general, just knowledge of contract?
Specifically in roofing?
I'm not a contract roofer. No, I'm not.
My question was, do you recall being asked about that?
I don't,
Okay.
honestly. It was 3 hours of.
Okay, so if I ask you, I'll bring it to this way, and if we need to change it up, I can. I asked you if you're a licensed builder, and I said, you're not a licensed builder, correct? And you said, correct. That's true, right? You're not a licensed builder. And I asked you if you ever worked in the roofing industry.
I have not ever worked.
And again, that was your testimony. You never worked in the
I
roofing
didn't.
industry. Okay,
Thank you.
sir. Did you ever work in the roofing industry?
I have never worked in the roofing industry. No, I have not.
And isn't it your testimony that, well, how about this? Didn't you testify at your deposition that your knowledge as to any issues or defects involving your case stems from someone telling you there's defects or issues with your roof?
What solidifies my knowledge?
I'm asking you, did you testify that way in your deposition? That you were relying on what someone told you to establish the issues you're claiming in your lawsuit?
You asked me, how did I know for a fact that it was valid, that I was making a valid point, and I said I had a contractor come out and give me an estimate, and he
Great.
said the same thing. Yes.
All right, so what I asked you in your deposition, so I'm clear.
Yeah.
It's,
All right, I am going to recap this case, but I feel like in about 10 minutes, we're going to have a lot of people joining us. So I'm going to wait to recap the case so I don't have to do it twice. So for everyone's asking what the case is about, just a quick overlap is the guy who's pro se, who's suing the contractor. He's a homeowner, doesn't like, he did not like the work that was done to his home, and he tried to sue him, or he's trying to sue him. Let's say that. And yeah, so there we go. And the guy is a construction worker, but he's not licensed, so he didn't do the work himself. He hired a licensed person to work on his home. I think that answered that. All right.
and to summarize, I asked you, so it is your position, and this is based on what your roof guy told you, correct? You said correct. So your position was based on what the roof guy told you, correct?
Correct.
All right, so that's what your testimony is driven from. Therefore, Your Honor, I'd say he lacks that ability to testify to any issues or claims and defects, or any aspect of the ability to articulate the purpose or the code or the requirements set forth by the Michigan Residential Building Code for this specific issue. He simply lacks that capability to testify to the issue. He's relying, and just for the record, he's relying on hearsay. I think that was his testimony, quite frankly, and he lacks that personal knowledge. A mere skill set or a mere experience with others doing their work is not appropriate basis to justify the testimony.
Okay, and so you just, I guess you must have had a deposition where you say you didn't have any.
I absolutely will. Can one of my mods drop it? They can find it faster than I can. It's going to take me a couple minutes. So if I see it come by with one of my mods, I will pin it and then I will announce it. Absolutely.
Experience or knowledge as it relates to being a.
He had asked me if I'd ever worked in that field. No, I have never worked in that field professionally. I've never been contractor, a licensed contractor. No, I have not. That was one of his question was specifically about whether I've ever worked professionally in that field. And no,
Okay,
I've been around job sites and I've been in the area of jobs because of my history and my family.
so without invoking the hearsay, meaning whoever it was that you came to have give you a quote after the work was done, your review of the work based on your own knowledge rendered what opinion?
I'm sorry, I missed that last second.
Your review of the workmanship that was done before you brought someone else in to give you a secondary quote gave you what opinion?
The opinion of the contractor that came in was that it needed to be completely,
No,
Objection.
your own personal opinion is what I'm asking about. Before you spoke to another contractor, when you saw the work that was done, what did you think?
that it was a complete miss and disaster.
And why did you think that?
I have pictures to show you why.
Because of what you saw?
Yes.
Okay,
And because of, I mean, I know the purpose of a nail, and the framing nails are longer than roofing nails. Roofing nails are short. Framing nails are long, so they anchor solidly into the wood.
okay, how do you know that? From prior experience?
From just a general definition of a nail or an anchor. I mean, my personal prior experience with building anything.
Okay, so what you're trying to show me is pictures of what you saw when the work was first done?
Prior, before, and then after, yes. My house had
When you
3
say
roofs.
prior, before, what do you mean?
Yeah, my house had 3 roofs on it.
Okay, so you're gonna show me pictures of what your roof looked like before
Before it was touched.
before
And then
Mr. Zany did
and
any
then
work,
after it was
then
done.
after it was work. Okay, you
Yes.
can approach and bring me
Well,
those two
thank
pictures. Did you show him those pictures?
I would object, Your
Yes,
Honor.
he
The
is.
court issued a scheduling order that required us to turn over exhibits 7 days in advance of trial. He didn't do that. So the reality is I turned over my exhibits, and what he's doing and presenting to the court today is outside the court scheduling order. I've objected.
Did you ever turn over your exhibits to the defense?
Yes,
When?
at his deposition, I gave him every bit of everything. He took everything from my files and copied everything. My folder, front, back, and side, everything. Took every bit of all my notes and everything.
And that included all of
Yes,
these
ma'am. Yes, ma'am.
pictures?
Yes,
So you
ma'am.
have the pictures?
Your Honor, I've reviewed pictures. I don't know if those are exactly the pictures I
Show-
reviewed, but I would tell the court he did not turn over what he proposed to advise as exhibits.
Okay, but if he gave them to you at the deposition, then he did turn them over.
These have been received, I think, in his complaints hearing.
Mimi, thank you. Wait, you guys can hear me. I was making sure my audio was still coming through. The court just got muted for a second. I don't know why. But Mimi, thank you so much for the $20 super chat. I appreciate it. Thank you so much. That's awesome. Thank you. Thank you. Somebody asked us a second ago. They did mute this. I feel like it's muted for like the next couple minutes too. I remember this happening. It comes back, but I saw a question. The plaintiff, is it a plaintiff? I don't know. It's because this is a civil lawsuit, right? Is it still a plaintiff? A plaintiff? Because it's not really. Is it a plaintiff and a defendant in a civil matter? It's a respondent and a. I can't. Yeah, but the homeowner is the person that's suing the contractor. The homeowner is, I don't know, the plaintiff in this case. The contractor is the one who has an attorney. The attorney's kind of arrogant. He's kind of, I don't know. He,
Flushing out something.
There we go, we're back.
Okay, back on the record. Okay,
but the attorney definitely met. I don't want to say he's messing with the homeowner, but he makes some just objections that don't matter, just for the sake of objecting on the record. I guess I don't know, but he definitely gets in the homeowner's head. Bad Scooter, thank you so much. 6 months, that is awesome. Half a year, I appreciate it, bud. I appreciate it. Thank you so much.
so these were pictures that were included in the complaint.
Yes.
Okay.
You just want to see the ones we're talking about right now?
I want to see the one from before the work was done by Mr. Zany, and then what you said you saw after.
Your Honor, there's a stack of photos he has, and he only showed me 2 pages.
Show him all of the photos that you want to show me.
I'm gonna show you the two that, I just showed him, the first two. She's not gonna even get those, she wants. This is the first before, and then this is what I seen when I went in after.
Okay, so this is,
the
no,
right.
you can back up,
Yes,
sir.
to the
You're way
right.
too
I'm
close.
sorry, I'm sorry.
Typically, my court
No, I
officer
know
would do
what you're
this, but I don't have one
I'm
today.
sorry.
Okay, so this is your
That's
roof
the-
before you had any work done?
To the right, yeah, to the left is the garage after. Yeah, but this is the
Okay,
inside the
this-
house.
All right, you guys know how nervous that makes me. I don't. Ever since I saw Ric Flair jump over the judge's bench in Las Vegas, every single time I see anybody approach the judge's bench, I get nervous. And just watching him do this, yeah.
This is the roof before any work was done?
Inside the house, yes.
Inside the house?
Yes,
And this is what?
the garage after he did it.
Okay, and then what is this?
That is
Do I have
inside
this
the
right
attic.
way, or is
Yeah,
it?
no, that was the right way. That's inside the attic.
Yeah, I pinned it and I didn't say anything about it. Mayor has to get back to work. Yeah, I think everyone knows by now, but for those that don't, Mayor lost his wife a little over a week ago now, and he's just trying to collect some money for costs. This is his channel, or not his channel. This is his GoFundMe page. I have verified it. So it is going to him and what he needs it for. So if anyone has a couple bucks, throw them his way. He would greatly appreciate it. He is a beloved member of the court watching community. He is, you know, on just about every channel. He's Mayor McWrench because he has a wrench on just about everyone's channel. He had one on mine, and then he, you know, thought he was too cool for me, so I had to take it away. But we're still friends. We're still friends. Mayor, you're awesome, man. Yeah. Let's go.
After he was done.
Your Honor, can I have what, dear?
These are the same rooms?
Yep. Those are the same room. That's
Okay.
the same room too.
You
Yep.
can.
I may,
Yeah, you can right there. You can go back to your,
may I approach that
Yes.
exhibit? Mr. Pryor, you just handed the court an exhibit indicating this was pictures after the work was done,
this one.
in particular this photo, correct?
The top one was the garage after complete, yes.
After shingles were on the roof?
No.
So it
no.
wasn't after the job was complete,
No,
correct?
after he was done putting the plywood on there.
All right, so for clarity's sake,
Well, that's new plywood, so yeah, he's touched that already. Yes.
great. So my question, for clarity's sake, this is not after the job is complete, correct?
The top one is after the plywood's been installed in the garage.
Correct. No intent to trick anybody. Your Honor, I'm pointing to the top portion of that photo. That was during the course in which the job was occurring, correct?
In the garage, yeah.
In the garage.
Yeah.
So let's be clear. In the garage, right?
Mhm.
Yes?
Yes.
During the course of the work being performed, correct?
The top one, yes.
Correct. And that's all. Hey, we'll fold it. How about that? And there's no trickery here.
Yeah.
Your Honor, if I may just speak from the well. Is that okay, Your Honor?
Yes.
So I have it folded for the record. I have your piece of exhibit, has a page 11 written next to it. It's what you purport to be a picture of the garage,
Mhm.
right?
That is.
We have to say words
Yes.
for the record so they
Okay.
can pick it up.
No,
Okay.
that's what he's doing is normal. He would instruct anybody that way. He's not being smart.
Again, the garage during the course of the work, not at completion, right?
Yes, after the plywood was applied. yes.
Great. So after the plywood would be done, they would do whatever they do for shingles.
All right.
So this is just midway through.
Yeah, I'm not even worried about that picture though.
right.
It's not one I'm concerned about.
Okay, so this picture you're not concerned about.
At this point, right this second, no, I'm not.
All
We
right.
were talking about the before and after of the attic of the house, sir. She asked me what that was and I explained it to her. It was the garage when it was done with plywood.
Your Honor, they're not objecting to admission, or I'm not sure if he's moved for admission, but that proposed document, he's not worried about it, doesn't think
It's not that I'm not worried. We're not
No, no,
talking about that right now.
So you're trying to admit this, not this, correct?
I mean, it's all been submitted and he has all of them as evidence. That is part of an issue. Yes, that is an issue, separate issue besides the nails that we were talking about. How I knew that there was an issue with the anchor points walking into the attic of the home was from the other picture on the other side.
Okay,
And
so
so I was,
he's
you asked me what it
objecting because
was.
you said that it's not, you said you're not worried about it, which essentially.
I mean, I'm very worried about it, but not at this point, right this second, because you only asked me for the 2 pictures.
Correct, but you gave me 3 pictures.
Right,
So
'cause
if you
it's-
want me to admit this as an exhibit, you're gonna have to be worried about it and you're gonna have to get through the evidentiary issues.
Okay.
I told you from the beginning that
Yes.
there's a lot of rules that comes to litigation. And I recognize you're at a disadvantage because he's a very experienced litigator. But that doesn't mean that those rules go by the wayside because you don't have that experience. So you have to answer the questions so that we can decide and flesh out whether or not this is something he needs to object to. I don't necessarily think Mr. Zaney is objecting to this one. Is that correct?
Not at this time.
I think it's this one he's trying to flesh out because you put them on the same paper. If you had to put them separately, then we probably wouldn't be going through this. So I can do one of 2 things. I can cut this in half if you like, and then we can just focus on this right now. And if this becomes an issue, we can bring it up. That works?
Yes.
Okay, can I have some scissors, please? So, Mr. Pryor, let me give you this one back, and then if you want to address, when you get ready to address this issue, then you can move or present that. So right now, we're talking about, this is the before, I don't know if I got this right. Okay, this is the before
Yes, ma'am.
of the attic, same place. This is the after, correct?
Yes.
Okay. Continue your testimony as to, and so you're saying when you saw this struck you as there's something wrong because you think it should look like this.
Absolutely.
And so you're moving to admit these as plaintiff's exhibit I would say 1 and 2. Correct?
Sure.
Are you objecting?
Oh, God.
I don't know what this technically falls under. It is a civil matter. I do believe it's small claims court. Most small claims courts are, anywhere from $1 to what, 25,000, and the whole price of this job was 6,500. Yeah, and the homeowner's just not happy that of the work, the quality of work that was completed, and he hasn't paid the last 1,000 he owes him. Plus, the contractor was starting to charge him more than he accepted. So that's what the lawsuit's about.
Okay, so these will be admitted as 1 and 2.
And I had mentioned when I walked up in there, there was a bunch of debris that fell down on top of me. I was gonna give you those pictures too. Those are
Okay,
the extra ones that he
This was-
asked about.
so you showed him the pictures of the
Yeah, he's-
debris,
He's seen them, yes.
and this was debris that, you said hit you.
Oh, you're right. You're right. There is a Michigan court law that if it's a small claims court matter, they don't accept attorneys. Maybe it isn't. I don't know it's general civil. So maybe this is general civil. I don't know. I don't know. I'm trying my best here, but I'm not an attorney, so I'm trying my best. Small claims, and then I think it's general civil after this. So this must be general civil. So yeah, I think you're right.
After the work was done?
Yes.
Okay,
Yeah. Check because they have a bunch of handwriting all over the pictures.
You didn't hear.
They're not appropriate exhibits to be submitted to the court's trial.
What it's
It's just my notes, just explaining what it is.
okay.
Each one of them just explains what I see.
That I'm not going to grant that objection just based on his notes. This is, other than the notes, you have an issue with that, the court can disregard his notes.
Ask them to lay an appropriate foundation.
Okay.
You don't need to be sorry. I think you're right. I think you're right. That's what I was saying. So yeah, it's don't be sorry.
What is this, sir?
That's the debris that was in the attic after I went up there that I had to clean up, that wasn't cleaned up.
So what you're saying is after the, Mr. Zaney completed the roofing project, this was the condition of the attic?
Correct.
Okay, and so how long after the project was done did you take this picture?
A few days.
Yeah, I seriously doubt it was because he said earlier that they only ordered 89 shingles. Was it 89? It was 80 something, 85, 89. I don't know, somewhere in that range. So highly doubt it was a full roof replacement.
And so you're saying, I see in the picture, looks like, is it Christmas wrapping paper and something gold? That
There
was
was a gold basket and some wrap paper over in a corner. I just threw it out there in the middle
Okay.
just to throw it out with the stuff when I cleaned it out.
But your testimony is that prior to,
Again, I'm wrong then. Just like I don't know. I'm just listening. I'm enjoying it with you guys. I'm not an attorney or a contractor. I've never worked on a roof before. The house I've owned 2 houses and neither one of them I had to replace the roofs on. So yeah, I'm just enjoying this with you guys.
this roofing project, none of this stuff was?
None of the roofing debris was up there. I mean, there was some miscellaneous stuff from when I bought the house from the last owner.
Okay,
A couple few things, but nothing
Okay.
major if you look at the original other
Okay.
picture.
your objection is, as to this exhibit is overruled. We'll admit this as plaintiff's exhibit 3. And then what is this?
That's the stairs that I had to pull. The one to the right is the stairs that I had to pull down to get up into the attic. And that's when the stuff was falling. I was just
Okay.
showing that it came down when I pulled the stairs down. That other one is a copy of the other picture that you just cut off.
Okay, so we could remove that now, correct? And then what is this?
Again, just when I pulled the stairs down, all the stuff that came tumbling down in my face.
Okay, so it's just another angle of this.
Yes, yes. Floor and everything that came out.
And then this just appears to be another angle of, it looks like a combination of your
Yes.
exhibit 3 and exhibit,
Just
Two?
different sections, yeah, throughout the roof that were also nails everywhere and broken boards and debris up into the insulation barrier.
okay, I'm going to include this with your exhibit 3 because it's just another angle of it, it appears. And then be admitted as part of your exhibit 3 as well, which is,
Yeah, I'm not a fan of this contractor. I feel like he did shady work. I really do. Throughout this hearing, I believe the homeowner. I really do. And he came with all this evidence. He just doesn't know how to present it. And yeah, and the attorney for the process, not the pro, the attorney for the contractor. Yeah, yeah, like I said earlier, he kind of nickels and dimes his objections. He doesn't want anything this guy says to be on the record, and he wants to frustrate him. He wants to get in his head, which I mean, that's his job, right? But it just seems shady. Seems shady. The homeowner needed an attorney for this.
to show the debris. You can continue, Mr. Fryer.
So when all this transpired and all this stuff was coming down, and I was trying to get it cleaned up, I was begging him to come back and do it. Never happened. It just never simply happened. So I ended up cleaning it up myself and not insulating the attic. So the insulation's still all sitting there. I had started to insulate part of it. My uncle went up there and started.
Oh, thank you so much, Deanna. Thank you so much for donating. That's awesome. I know Mayor said he had to go back to work, so he's probably not here. So I'm gonna say thank you in his stead. That is awesome. Thank you so much for doing that. And yeah, it's hard, and I'm sure you know it was hard for you when you went through it, and still is. So thank you so much for doing that. Speaking of people coming in, we got a Biggin raid. I don't know who this Biggin guy is. Have you guys heard of this guy's channel before? Biggin? Biggin. Is that how you say his name? Biggin? Is it Bijin? Bijin? Bijin. Bijin II. Thank you so much for I'm just kidding. Biggin, thank you so much for the raid, bud. Thank you so much for the raid. I need to go I really hope you played the NFL clip tonight because I was waiting for that the entire video. I really hope you played it, and I'm gonna have to go back and watch it after my stream's over. But yeah, Santa raid. There we go. If you can't pronounce Biggin, like I can't, Santa raid. Thank you so much, Biggin. You're awesome. He did. He did play it. He did play it. All right. I'm gonna jump over there after I finish this stream so I can watch it. Cause I wanted because I didn't want it to get spoiled for me. I'm a big NFL fan, especially with fantasy football coming around. And speaking of which, we've got a big fantasy football league coming up here. We have a bunch of creators. I'm not going to drop the names yet. I, I'm not going to do that. I'm not going to do it yet. But there's a lot of creators, and a few judges that are going to be in the fantasy football league. We're going to do the draft probably late August. We haven't found a date yet, but we're going to have some fun. We're going to have some fun. All right. For all the big and raiders that just joined, this is a civil case. Now, there's a homeowner suing a contractor. The homeowner does not have an attorney. The contractor does. The homeowner is upset with the quality of work that was done to his house, and he feels like he was overcharged. And that's what he's trying to prove. we're about, I'm gonna say about 40% of the way through this hearing. We still got a ways to go. But what has happened right now is not the defense attorney. Why do I keep saying that? The attorney for the contractor keeps objecting to everything the homeowner is saying. The homeowner is trying to show evidence of the bad work, and the attorney keeps objecting to it and not allowing it into evidence. So the homeowner is starting to get frustrated. That's about where we're at right now. But Biggin, thank you so much for the raid. I appreciate it, bud.
Started to, but he kept getting, every time he was trying to put the insulation between the rafters, he was getting cut with the nails on his arms and hands and stuff. And so he basically said, no, we gotta figure out what's going on with all these nails.
Objection here,
first."
sir.
That is
Sorry,
his-
do it. He refused to do it, basically, and so I didn't insulate the attic yet even, and so the last couple of years, I've just been paying the additional expenses of the heating and cooling. It never got resolved, and I assumed that it was gonna be eventually, and after a couple of weeks of dealing with this, with the
Kind of. She allows it, but she kind of forces him to explain it in the right way, and then the attorney objects to it. You're gonna have to watch. But yeah, she allows it, but it doesn't go smoothly.
defendant. I had stopped over at the party store that is owned by the defendant, and
Objection, Your Honor, lacks personal knowledge as to the owner of the.
How do you know that he owns Party Store?
they personally both told me they own the party store. All three of them do, him, their brothers.
Who personally told you this?
Simon.
Simon told you he owned
It's a
it?
store.
No, I didn't ask you, was this store? I said, did he tell you that he owned it?
Yes.
Okay, okay. Nonetheless, it's not even really relevant if they own the store anyway, so. Right, we don't care who owns the store. You stop by to the store.
I
when
stopped
he
by to
is.
the store for my fiance to run in and play some lottery or do whatever, get their drinks or whatever they're gonna do, and I stayed in the
No, I have not played that case. I'm gonna play that tomorrow night. I promised a few people I'd play this case tonight, so I'm playing this case tonight. The Judge Simpson case got moved till tomorrow. So the Judge Simpson case, I'll play it in its entirety tomorrow. That's another hour and a half hearing. But that will happen tomorrow.
car, because I knew the situation between us, and I didn't want to be disrespectful, so I stayed in the car. Well, when being in the car for less than 3 or 4 minutes, the defendant walked out, opened the passenger side of my.
Objection, Your Honor, it's relevant. It doesn't go to the purpose of the nature and scope of the complaint.
You saying the defendant opened your door
Opened my vehicle door.
about this issue?
Yes, and was.
Well, wait, I gotta address the objection. How is that not relevant?
Because it doesn't go to the contract, the breach of contract, or damages relating to the breach of contract. And that's nature and scope limited. If you recall on this record, we filed, because this whole oratory existed before. We filed a motion to, as it relates to the complaint, and the court addressed that on the record respectfully. You narrowed it down to simply, because I need clarification, what am I defending against?
Right.
This is a breach of contract claim, and that's what we're here presenting today. And this attempt by this plaintiff to misalign reality and facts as it relates to other instances is not relevant to anything as it relates to the nature and scope of the complaint. Contract, breach, damages pertaining to this. So this is way outside the scope.
Right, I don't know what the door opening, I do remember addressing something, but it was so long ago, I can't remember exactly how the door or this interaction has anything to do with the case, if anything.
He parlayed that into a claim of assault.
Oh, okay,
Both
yeah,
sides claim
I
assault.
said we're not dealing with assault in general civil.
Correct.
So if that's what you want to share, no, that's a criminal matter that you have to share.
No, I just was making mention of what happened, what caused me to come in here to try to do something about this, because
Well, that
I
is,
knew that,
well, this is what caused you, I would
Right,
hope.
well,
So all
yeah.
the other,
yeah,
you
the
can.
final straw to
Got
not
it.
allow any rectification in my home, because
Okay,
there was mention, I mean, you want to talk about trying to realign facts and to redirect the whole case into.
Again, relevance.
yeah, but do you have any more evidence that supports your breach of contract though, like receipts, any more photos that you wanted. It looks like you might have some text messages there. I don't know what those are, but
This is,
whatever evidence that you are purporting to present to the court to support this claim of breach of contract, make sure you show Mr. Zaney, Mr. Edward Zaney, and then you can proceed to try to present. I don't know. I hope all of that's not evidence.
no.
Oh.
No. I'm just, the only thing that I have is the estimate from the other contractor. As I got it back. And then my payments to Simon and all my receipts from everything that I paid for. Oh yeah, here's the other contractor.
Oh, I thought you said there was some bills for that you received for dump fees or
No, on his invoice, he.
an invoice.
added
That should
400
be,
yeah, I got
I'm gonna
that.
need the invoice.
I got it.
Um,
I'm gonna object then.
the
And we can take
invoice.
it piece by piece,
Oh, yeah, we gotta do it. You're objecting to the invoice.
which is,
I'm asking for the invoice that he said Mr. Zaney gave him. Show, you have to show him.
I'm not gonna object to that. No, my
Okay.
objection is gonna be to the third party, the other document.
The contractor, you need the contractor here if you want to present his statements.
Well, of course, assuming he's a contractor.
Well, yeah, I'm just taking his word for it.
Yes, Your Honor.
So I don't know who he is.
Respectfully, I don't mean to be disrespectful.
Yeah, I don't know who he is, but if you got an estimate,
I
you
did.
can't just present. So there's a rule called hearsay. It's an overwhelming rule. It's overwhelming for attorneys. It's overwhelming from judges. So you can't present an out of court statement to prove something. So that would be an out of court statement, that estimate. If you want that to come in, you need the person who made that estimate to be right here under oath in order to get it in here. As it relates to the estimate. This is a past due. Okay, this is a total invoice that you're submitting here. It says to Anthony Pryor. Shows the total amount, dump fees taken to Granger, past due. And you're not objecting, so this will be plaintiff's exhibit, where we have 4.
Yes, I believe we're at 4, yeah. I think you
Yep.
joined one.
I did. Okay, and so. What other evidence other than the estimate that you wanted to
I have
present?
my payments to the defendant.
I don't know that they are, I don't think they're disputing that you've made payments of a certain amount. You
Okay.
said you paid,
5,500.
that's on here, so they're not disputing that. So you don't need to show me that.
And then my receipts for everything.
For the materials, I don't think they're disputing that you paid for the materials either. So anything else that you want to show for your breach of contract?
No, just that he never finished the contract. He never finished the job.
Okay, so you're saying he never came back to remove or to complete the back entryway? He never removed the debris, the eave troughs never were put back up?
Correct.
And then you believe that the workmanship fell below the standard?
Absolutely.
Okay.
Oh, and I want to say one more thing, about the craftsmanship and meeting the standards. I'll make one reference point on the weight of these construction materials, whether they had any anchors or not, is extremely heavy.
Objection, Your Honor, and as far as any basis to make this testimony, present these proofs to the court, he's not laying the appropriate foundation for the testimony which he purports to submit to the court. I think his experience is extremely limited in many aspects of roofing. If there's any,
My experience is limited in roofing, so even when giving testimony, you gotta explain what you're talking about, because when you just start talking about anchors, it's like white noise for me. I don't have no clue what you're talking about. So the lack of foundation, I'm gonna grant that objection. If you can explain what you're.
Did anyone else catch the irony there? The lack of foundation with her lack of understanding about anchors. Anybody else? Please, somebody. I found that kind of funny. I know the homeowner right now is not liking life right now, and yeah, and he look at him right now. The way I have it paused, he's praying. Why didn't I get an attorney? I'm losing this case because I do not have an attorney, and this shady contractor does, and I'm losing.
Talking about in more detail, or
Okay.
what you're purporting to provide to the court.
I'm sure he's gonna address it in his portion of his defense, and there was a man that was hired to come into my home and create a video. And that video, I actually requested for.
Hired by whom?
Hired by the defendants
Oh, so
to come in and do a video
prior to the work or after?
after the work, before this case, as a part of the defense.
Oh,
And there was a mention in there, there's two mentions in there, and I just want to make mention of those and put my part out there right now, because
mentions in what?
in the statement from the person that came and did the video of my roof inside my home.
Not relevant, Your Honor, it's not in the evidence.
Yeah, I'm not sure what you're talking about.
Oh,
So if they
Well,
present, so you get your chance to present your case now. If they bring that into evidence, you get a chance to rebut
okay.
later. So that's not in
I'll
evidence
handle it
now. I
then.
have no clue what you're
Okay.
talking about,
I'll
to be
handle it.
honest.
Thank you.
Okay. Anything else you want to provide before he gets to question you?
Just want to make mention of the escapades in the charades, in the disastrous amount of time wasted from the defense on a whole bunch of stuff that would never be done from any other attorney in a case like this.
Or we're
Objection.
talking about the attorney or the, talking about the contract?
The defense case, period. But we'll see as we go.
Objection sustained.
Go.
Thank you.
You can cross-examine.
Your Honor, would you entertain a motion for direct verdict this time before I proceed with the,
I think there's a question of facts. You can continue.
provided the court a notice indicating a balance due, and that was entering the exhibit. Do you recall?
I don't know if you guys caught that. So the attorney essentially said, Judge, can you just decide on this case now so we don't have to go any further with this? And the judge said, there's still a question of facts. That gave the homeowner an opportunity, you know, he's like, she hasn't decided yet, but the attorney's playing this game. Like he is not represented, and I'm going to play this game. It's like, you know, when you're level 100 in a game and you're going against a level 1 and you're just toying with them, that's what the attorney's doing. And I don't like that. I don't like that. Again, it's what he's being paid to do. And, you know, this is, you know, walking in the park for him, but it's just, I feel bad for the homeowner.
All that? Or exhibit 4?
Yes.
Okay, you would agree that that out properly identifies the nature and scope of the contract? Between you and Simon Zaney?
No,
That was exactly the document you received prior to work beginning, correct?
no,
You received an estimate prior to the work beginning?
no,
You never received anything?
no,
Are you sure?
positive.
Didn't you testify your deposition that you had in fact received and reviewed that prior to the start of the work?
No, he physically told me how much he was gonna charge me. That was the scope of our contract.
Would you agree that the scope of your contract included that you provide for materials?
Yes, he asked me to buy my own material.
Forget asking. You agreed you would provide materials, correct?
Yes,
And he would provide labor only, correct?
Yeah.
So to the extent he had to do any labor, he would do that, and you would provide everything else. Agreed?
yes,
Was there any indication in this, at least as it pertains to your exhibit, or that he would, or his people would install any eaves troughs?
they removed him.
I'm asking you, was there any nature or discussion in this document, exhibit 4, that relates to that?
Exhibit 4 doesn't relate to anything in regards to that because it wasn't before the contract was done. We discussed everything that was gonna be done at the time when we made the agreement for the price.
You would agree you never discussed actual ease troughs,
We
correct?
did, we did.
Where did you
actually.
say that in any of your complaints?
Where did I say that? I mean,
Yeah.
it's like one of the least,
So you don't care about it?
it's not, no, it's not
Alright.
that I don't care about it, it just wasn't what my main concern was. It's just part of the issue is that there's one more thing that he didn't do.
Okay, as far as a dumpster, did you provide a dumpster?
No, Simon brought his trailer.
Well, you would agree that'd be something under the scope of your agreement, because he was just doing labor, that you would provide a dumpster.
No,
Yeah, that's kind of a flaw of mine. I feel bad for everybody. I feel bad for everybody. I feel bad for this attorney for coming off as a jackass. I don't know. I don't like making fun of people. I don't like feeling bad for people, but it is what it is. It's what I do, I guess. I don't know. It's my head. Legal Fiction, thank you so much for the 10 gifted memberships. I appreciate it, bud. Thank you so much. Welcome to the 10 new members. You're awesome, Legal Fiction. Thank you so much.
he said that he would bring his trailer and get rid of everything within the price of $6,500.
What documentation do you have to prove that?
A verbal agreement?
Do you have anything in writing to establish that?
I mean, your contract right there in front of you says that I would pay him $6,500 labor for him to do the whole job.
Okay,
If
so
he
you would
removes
agree that
parts-
this is the contract?
I mean, that's my proof that we had any kind of a contract.
Would you
Yes.
agree this is the contract between you and Simon Zanin?
No.
Is this the same thing that you're talking about?
Correct, Your Honor, it's his exhibit. During the course of your pleadings, did you supply this document to the court?
Yes.
Did you cross out the past due or the word past, like edit it and white it out in your pleadings? As a result of receiving this document, did you threaten Mr. Zaney?
No.
As a result of collection activities, did you ever threaten Simon Zaney?
There's been no collection activities whatsoever.
Okay. You'd agree you did in fact receive a copy of an invoice indicating past due amount?
With I begged for it.
You
I
agree-
begged
you
for it.
agree-
That's proof.
That's not my
Yes.
question, sir.
Yes,
Focus
yes.
on the question, it's gonna go a
Yeah.
lot smoother.
Yeah.
You would agree you received a copy of your exhibit 4 from Simon Zaney?
Yes.
You agree the
After
copy in which you received indicated it said past due amount?
which I had a problem with.
Okay.
Yes.
I'm asking, did you receive it?
Yes, I did.
All right.
Absolutely.
Is that the amount that you would agree that Simon Zaney invoiced you with $1,397.60?
That is the amount he invoiced me.
During the course of your action, in response to Simon Zaney's counter complaint, have you provided a counter affidavit?
In regards to his counter complaint, have I provided a counter affidavit
Correct.
for what?
I'm asking if you ever provided one, sir.
Don't know the purpose.
So you'd say to say you never.
So yes or no then?
I don't.
Okay.
An affidavit.
You'd agree you didn't buy the materials in this case until, at least, how about this? I'll reword that so it's a fair question. You were invoiced from ABC Supply Company on or about November 4th, 2022 for the items you purchased from ABC, correct?
Objection, we've already addressed that.
That's not an appropriate.
Objection, he asked you that and you answered?
We've already answered that earlier. I
No,
covered
he didn't
that.
question you about it, so you have to answer the question. Now, if he asks you about it the second time, then you can object and
Okay.
say, ask and answer.
The link I just posted is the celebration of life with Mayor. That's happening. We're less than a week away from that, aren't we, Mayor? When is the exact date? I'd have to click on it to see it, but we're probably just a couple days away from that. So yeah, check out the link I just posted, bookmark it, make sure you're there. It's gonna be fun. We're all gonna be there.
Yes, I purchased some of the materials on November 4th from ABC.
And namely, you purchased from ABC Landmark Colonial Slate shingles, correct?
Correct.
And then CT Shadow H&R COL Slate.
Yeah, it's the same shingle, it's just a cap for the ridge.
Great. Those are the items you purchased for your roof on November 4th, 2022.
Right.
And on that date and time, they were performing the services on November 4th, 2022?
It was that day or the next day, one or the other.
Or the day before, November 3rd?
No, because no,
You sure they didn't begin services on November 3rd, 2024?
no, the day that he started was the
Excuse me,
day.
22. November 3rd, 2022, had they been performing services on this roof?
He might have started the tear off on the 3rd, but I don't exactly remember, but I know on the 4th was the date that he was there to start it, and he needed the shingles, so I went straight over there and did it immediately.
Does this roof leak?
Yeah, Peter, I agree. He's just doing a job. I mean, when you're an attorney and you're a seasoned attorney and you're going against a pro se, he probably did very minimal work on this case. He just read what was going on. He's like, I got this. He doesn't have an attorney on file. Would have been hilarious if he showed up and there was an attorney there, though. But yeah, he's definitely playing with his food. I don't know who said that earlier, but that was spot on.
At this point, not that I know of.
All right, does this roof, any loose shingles that you observed?
A couple have, actually, a couple pieces. I don't know if they were just shoved in somewhere or like extra cut off debris or whatever. Over the course of the last year and a half, I've had a couple shingles in my driveway, but nothing that was any full pieces that you can see where it came from.
Any nails protruding through the shingles?
At this point, they are not backing out yet.
And I know I asked you this, the roof does not leak, correct?
Not that I know of at this point.
There's no OSB or the plywood coming off of the roof, correct?
Coming off of the roof?
Correct.
Not at this point that I know of.
And the two items, sir, do you recognize those pictures? What do you recognize those pictures to be?
921 West Lenaway.
You do, and that's your residence, correct?
It is.
And do those pictures, excuse me, accurately reflect the condition of the roof today?
I mean, aesthetically, you can see the roof.
Okay, so that's an accurate reflection of the condition of the roof
The
today.
aesthetics look great.
I'm
No,
asking,
that's not the, you have to answer
Yes.
the question. Is
Yes.
that the, is that,
Aesthetically, yes.
is that how the roof looks today?
Yes.
Your Honor, defense A.
A.
Thank you. You provide the court and move for admission of defense exhibit A and B.
Any objection to defense A?
And approach.
Yes. Defense A is admitted.
A and B, Your Honor. I believe
A and B.
I did bifurcate them.
Okay, sounds
If
good.
you, if you like to change it, I have no problem.
No, it's fine. There's different angles of the roof, correct?
I asked you whether or not there's any nails protruding through the shingles,
Yes, we did.
and there's none, correct?
Already answered.
Answer it again, please.
Not that I know of at this point.
Yes, but you said the roof was completed when? Yeah,
November of 22.
and they started in November 22.
Yes.
But the contract or the agreement was in the beginning of 2020?
22 in May.
I think the court was looking at a typo in the top right corner.
Oh, yeah, I'm just trying to look at the invoice and why it says November
It was
20.
a typo, yeah.
Okay, so got it. So makes sense. You can continue.
Thank you, Your Honor. So as you sit here today and you present this case to the court, your concern is that nails are sticking out the bottom of your roof, correct?
No.
Your concern is that those nails that are in, that you provide the court pictures of, are going to somehow protrude through your shingle?
No.
So what is the issue with your case today? What do you feel specifically as it pertains to this nailing issue you presented?
Okay.
And I ask you to limit your question based on your personal knowledge.
And it is my personal knowledge and experience and understanding as an adult, as any other human.
Whoa, everybody's gonna calm down because I have no, I'm an
No,
adult.
I know.
but I
I'm
don't know
saying-
anything about roofs.
Okay,
So you can do your personal
if
knowledge.
you take a nail and you use it as an anchor to hold two pieces of wood together, that it should go into both pieces. The nail that goes through the plywood should enter into the trusses. That's when they're framing a home.
Objection, foundation lacks knowledge.
Okay, these are the nails, correct?
Yep.
What are you saying? What are the trusses? What is
The
that?
trusses are the cross, see in the other picture to your right?
Yeah,
Yeah, those long boards that go straight up and down the picture.
these ones?
Those are trusses. Yep, those are what hold the frame of your home.
So you're saying
Objection.
that, so what your personal knowledge or belief is that the nails are supposed to go through that?
You're supposed to, yes, they anchor the plywood on the outside to those, yes.
Okay.
Yes.
I object on that one foundation. is responsible.
Well,
Foundation.
he's answering your question. He said he believes, you said based on his personal knowledge, he believes that as an adult.
Fair enough. Sir, what year was your house built?
It was built in 1908.
And you would agree that there was 3 layers of shingles on this roof?
I would agree that I was told by your brother. That there
My
was
client,
three
sir,
layers.
my client today.
Oh, excuse me,
Yeah.
your client, that there was 3 layers of shingles on my roof before he started the job.
You have no reason to dispute that? All right, you would agree that in those pictures that you provided the court, there's these things you call trusses, correct? Yes?
Yes,
On top of the trusses are these things, these 1x6 planks of wood. You agree with that?
I do agree with that.
And on top of that is this sheathing, or do you know what sheathing is?
That's plywood.
All right, so you want to call it
Sheathing.
plywood. Would you,
OSB decking, whatever you want to call it.
so then you have maybe a waterproofing layer?
Moisture barrier.
Sure.
Yeah.
And then shingles, correct?
Yeah.
All right, so,
So all that weight.
great. My question, just so the judge can understand the chronology of what gets applied to the roof. On top of that, those things that you call trusses, this 1x6, these pieces, planks of wood, those stayed intact. Those are from the original house, correct?
Yeah. You
All
know
right.
what those are for?
On top of that was OSB, correct?
Right.
These nails in which you're showing the court go through the 1x6, correct?
1x6, that is correct.
Okay, thank you. Now,
One,
that's my question. You can address it with the judge when you finish.
Oh, hey there.
Oh, hey. How are you doing?
Hey, I'm good. How are you doing, bud?
I am okay. Everybody,
Alright.
this is Jedi.
Hi.
I think everyone knows Jedi. Jedi is going to
hope
be
so.
kind of taking over my stream the rest of the night. Kind of. I'm still
we're
going to
gonna
be here.
try.
I'm still going to be here. I don't want to get too much into it, everybody, but I had a little scare at the park today, and yeah, I was essentially in a medical tent for a couple hours today, and yeah, and I'm struggling to get through this. I should not have picked this clip to do tonight, and my head is pounding, and I can't read and concentrate on the video at the same time. So I'm tapping Jedi in because it's Jedi.
That's how we roll.
So she's gonna be here. I'm gonna be here, and I'm just gonna take a back seat, and she's gonna yell at me pause when she wants to talk. But she's taking over the stream for the most of the remaining of the stream. You good with that, Jedi?
Right on. Now, pause. So, since we're already paused, did I just hear that these two are brothers?
No, the contractor has a brother that's a partner of his.
Oh, okay. All right.
So when he said I was talking to your brother, that was the homeowner talking to the contractor. Like, I was talking to your brother. I'm guessing the
Okay.
brother probably works for him. The
Okay,
contractor owns a bunch of businesses. That's why he was saying earlier, like, I had to go, and serve you at the party store. And the judge, like, the party store. Why are you talking about a party store? It's like,
Yeah,
because
what's
he
the
owns
party
that.
store?
Because he
Oh,
owns
gee.
that. That's how I had to
Oh
get
my
in
God.
contact with him. But then
Alright.
I went to the party store, and then my wife had to go in because I I didn't want to go in and get into a fight with him, so my wife had to go into the party store. So this is that guy that just owns like a ton of businesses and just kind of, you know, does them as cheap as possible. That's
Yeah.
the kind of that's what I get from this contractor. But again, he has an attorney. The homeowner
Well, no.
doesn't.
Now, someone in the chat is saying that the attorney is the contractor's brother.
Oh,
True or false? I don't know.
I don't know the answer to that.
Right?
I don't think
All right.
I don't. Yeah, I mean maybe
We'll see.
that would make
Yeah.
it even shadier.
Right?
All right,
All right.
Jedi.
You need to go get some water, okay? I need you to hydrate. And
I've had a ton of water. I'm good
okay,
on water.
good.
I'm just
Okay.
gonna hang back. I'm gonna let you
Sure.
you read the chat. I wish you could bring up chats. I wish there was a way I can give you the ability to do that.
Yeah.
But I don't think there is. Hold on.
Let's see.
No. I've got four
Yeah.
options. Edit name, edit mic settings, kick, or ban. That's all I got from you.
Oh,
All right.
are you gonna
So
ban me?
I mean, only if you do too good of a job.
Oh, okay. Okay.
All right.
All right.
We're going. We're going.
Let it rip.
She gives you the opportunity. You're aware, sir, that the city, that Simon Zaney pulled a permit with the city of Lansing to do this roof, correct?
Yes,
And no reason to dispute that?
not,
No, and you agree that the city of Lansing inspected and found about that permit, correct?
correct.
All right, you agree that Simon Zaney is a licensed contractor?
I have to, I guess, understand that he is,
You,
according to the document you showed me.
no reason to dispute that he's a licensed contractor, correct?
Correct.
All right. What's the status of your ownership on this residence?
In the middle of purchasing it. Just like everybody else, most.
Do you have any ownership interest in this place?
Absolutely.
Well, as it stands now, short of the placement of the nails, as I understand your testimony to be, there's no other problems with the functionality of this roof. Correct?
The problem that I have with the functionality of this roof is the OSB is improperly anchored to the framing of my home. And through that 1x6.
Just object on the grounds he lacks the foundational knowledge to testify to that in this court.
Half the time when those nails hit that 1x6, the
Well,
1x6
there's an
split.
objection, so it means I have to address it. You can't just talk over the objection. Saying you don't have the foundational knowledge to address that, so you're trying to give some expert testimony when you've already indicated that you don't have the knowledge to do that. And that's why you had to get another person to come and do the secondary quote, but you didn't bring that person to court. That's what the objection is. So I have to sustain it because you've already established that you don't have the requisite knowledge to give this expert opinion about whether or not this was done properly or not. You can continue with your question.
Thank you, Your Honor. Isn't it true, sir, you were convicted of a crime of theft and dishonesty in the 54A District Court within the past?
What's
10
the
years?
relevance?
It's allowed under 608, Your Honor,
Why is it relevant?
because it goes to veracity of the witness. It goes to, and that's exactly what it's used for. And the question was asked a certain way for a certain reason. There, sorry, I should be standing. I believe the court rule allows for crime of theft and dishonesty of the testifying person to be inquired upon, as long as, and so as it is dealing with the crime of theft or dishonesty is within the past 10 years. If the court doesn't want to address that, I can try.
I'm not interested in criminal history.
Thank you.
Well, good effort, attorney.
Yeah, she muted it again.
Oh, did the judge mute it, or are they just
Yeah,
being quiet?
The judge muted.
Oh,
No problem.
She's back. We can tell because she starts clicking again.
okay.
Still quiet though.
Lone Wolf said crimes of moral turpitude could be relevant. I love that word, turpitude.
When you use words that have syllables more than 3, I feel like you're making fun of me.
I am not. I just like the word turpitude.
Yeah, we keep it to 3 syllables or less. Otherwise, I feel like you're making
Or
fun
just
of me.
grunts. Nah.
Yeah, yeah. Stop pushing those big words.
I
It's
know,
not even.
right?
There's not even that many
SAT
letters in that
words.
word. Why is that? Why is that? Why does that word have? Why does that word have so many syllables? Why does it have so many letters? Such a short word.
Oh, I
Interpretude.
love pedantic. Good one,
Oh,
Michelle. Oh, see,
since
his
we're talking
lips are
about
moving.
syllables,
Yeah.
yeah, I was supposed to cut this out. I was supposed
All
to.
good.
This was I think Lucy is the one who told me about this clip. She told me about this clip as I was already watching it, but
Yeah,
she gave me timestamps on what I should cut out, and I completely ignored it apparently.
that's all good.
Yeah.
Shallow and pedantic.
Ah,
Views.
we're gonna talk about syllables. Can we talk about something real quick? Why does World Wide Web get replaced with www? World Wide Web has 3 syllables.
Right.
www has 6. Can we
Well, not
talk
if
about
you
that for a
say
minute?
dub dub dub
Just saying.
like you're from the 90s.
Yeah, nobody says dub dub.
We're
No
not
one
trying
has
to
ever
make
said
fetch happen here.
no one has ever said that.
It is
Free dub.
shorter to write. Good call, Grizzly Old Fart.
It's shorter to write, it's not shorter to say. So there's a difference between
Right.
writing and saying it though.
Yeah, but when you're typing it, you
Yeah, when you're
know?
typing it, but when you're saying it, you know, when I'm giving you a website, say www.google.com. It's a lot faster to say World Wide Web Google.com. Just saying.
Poots. No 50-cent words in this nickel chat.
Yeah, thanks for the super chat, dudes.
Well, and while we're at it, I mean, should we extol the virtues of the slash versus backslash? My goodness.
Or the hashtag. When did hashtag become a thing? Can we get
It's
rid
the
of
pound
hashtag?
sign. It's the
Yeah,
pound
that's what it
sign.
is. It's the pound. You know, when
We're
when
dating
when you're it's like
ourselves.
hashtag love you too. No, just pound love you.
Right,
You're wasting time and energy right now. And
right.
when we're living in a generation that is all about text and all about abbreviating everything, like, and then yeah, it doesn't make sense. It's pound.
I
It's
know.
always been pound.
I know.
Don't ask questions you don't answer to. You know what? I will ask all the questions. Every single one. Every last question. I'll ask them all. All right. Am I gonna have to fast forward this?
I don't
Why is
know.
it so
Like,
heated?
is it? And it's not.
As far as
Oh, there we
optics,
are.
again, there's case law that relates directly to this within our brief. Uh, The
Oh, we got case law. Look out.
any defects or omissions, minor in nature, to the extent the builder is considered as substantially performed on the contract, the entitled to only recover contract price minus damages for the cost of correction. There's been no testimony as far as correction, but what needs to be corrected. And there's another case a little bit more on point that deals with the nature and scope of the And in 1 second, I'll have it articulated for the record, Your Honor.
You gave him a copy?
I did, I provided a copy.
So we're gonna have to give him an opportunity.
I actually think I did. I think I muted it instead of paused it a minute ago, and I let it play for like 5 minutes on mute.
That's
All right,
cool.
I need to know. Do you guys want me to rewind it? Because I think that's exactly what happened. It was muted,
No.
and then I meant to hit pause, but I actually hit the mute button instead.
I think we get the gist of it.
Yeah,
Lawyers
I do.
lawyering.
Yep, I agree. I agree.
Need to read this. He's not an attorney.
No, that's fine. You want me to do that now, Your Honor?
It would probably be best to let it so you can follow along versus drowning and not understanding or following your arguments.
And for the record, Your Honor, majority of these were asserted in our affirmative defenses when we filed our response, and has had the opportunity to take those into account, both, I think, prior to today and at the time in which we pled them originally.
We'll give him a moment to read it.
Yes, ma'am.
I bet there's words in there like henceforth and heretofore.
What did I tell you about syllables?
Damn it.
Cut that out. 3 syllables or less. Otherwise, you're making fun of me.
Eh.
I don't know what this henceforth word is. I read that in Shakespeare once. What's up, Iron Arthur?
Oh.
Good to see you, bud. Hope you're having a great night.
When you finish arguing, you'll have an opportunity to counter what he's saying, okay? Did you finish reading already?
Well,
I'm
I
just
am
getting-
finishing now,
Yeah.
and I'm just skimming through the last couple pages because.
Well, you don't want to skim
No,
through.
I'm
This
just
is
saying,
a,
'cause-
this, do you know what this motion is that he's giving you?
Yes, he is trying to basically make case in point against me for other references to other cases and the outcomes in those cases that pertain to certain things that have to do with my case, like trying
Yeah.
to make comparisons.
Well, that's what we do in courts.
Yeah.
So he's filed a motion, or he's filing a motion here because you've completed your case. So after a plaintiff complete their case, if the other party doesn't believe that they met their burden, they can make a motion to the court to kick the case because you haven't met your minimum burden. That's what he's doing now.
Okay.
And he's giving you the legal basis that he believes it's appropriate for the court to kick it. That's what those other cases are for. That's how we operate in court. We use court rules, we use case law, and we use statute. So he's relying on these cases as the basis as to why he believes you failed to do your due diligence in meeting the minimum burden, and because of that, the court should grant this motion that he's making now to dismiss your claim before requiring them to present a defense. So that's why I'm giving you an opportunity to read it, but if you're not interested in reading it,
I have read half of it.
you just
but,
want to
I mean,
skim it.
it's
I'm-
no, I mean,
I'm giving you the time to do that now because I recognize you're not an attorney and I don't want you to be bombarded or overwhelmed. But if you're not going to take that time
No, no, no.
meaningfully, I can guarantee you, I have millions of things I could be doing today because I've got all these things I need to review and sign. So if you don't want to take the time, we don't have to, but it's up to you.
and it's not that I don't want to.
Okay, well then I want to see you reading it and not just throwing it off.
Man, reading under pressure though. Ugh. I don't think he's gonna internalize much of this.
No, there's no way. Have you ever tried to code under pressure when someone's over your
Oh.
shoulder?
I hate that. Hate it.
Yeah, it's like, don't.
Absolutely.
Can you please look away while I hit the period button and then go find what I'm looking for? I don't want you to see that I'm doing this. So look away for a second.
Right. I know, Lone Wolf. Hashtag don't watch me read. Nice one, each and everything. Sense. There's just something about like when someone's watching you do something, it's like, stop. I think he's staring at words at this point. Like I don't see how like he's really like internalizing, comprehending, because that language in those briefs can get really thick.
No, it is. It is
You
really thick.
know,
I feel like it's written that way on purpose. It's not written in
right?
common tongue.
Right.
That I mean, otherwise sovereign citizens could potentially win, right?
Right.
Like, oh, we're gonna talk all high and mighty in these legal briefs just because people that went to law school will understand it and everyone else doesn't.
Right.
I mean, what if
Nightmare.
all law briefs were, like the Ten Commandments? You shall not kill. You shall not steal. I mean, if they were that plain worded, we wouldn't need lawyers.
Right. Well, I mean, what if briefs were just, briefs or boxer briefs? Just saying.
I mean,
Thank you. Good morning, Your Honor. Thank you. As indicated here, the contract must be established, breach must be established, and the burden of proof all falls with the person pursuing the claim. This is, again, a breach of contract claim. The damages as indicated are limited. There's been no proof on this record, I think, as to the relates to the nature and scope of the breach or anything as it pertains to a breach, specifically failure to perform or performance doesn't comply with the contract requirements. Essentially, they're trying to pursue an implied warranty for the nature and scope in which the construction occurred. However, I don't think that was properly identified. And if it were identified, it has to be clear that this individual is only limited to not optimum perfection, but conformity to the specifications. There's been no testimony that the specs in which this roof was installed don't conform to the Michigan residential code. In fact, the contrary is true. Licensed contractor pulled a permit, city inspected and approved the permit. In addition, and that's Oakwood Villa Apartments, Inc., the Gula 9 Mishap 568, 1968. Breach of contract need not be precisely established. However, uncertainty as to the fact or amount of damages caused by the breach is fatal. Home Insurance Co. versus Commercial and Industrial Services Security Services, Inc., 57 Mishap 143, 1974. Damages cannot be conjectural, speculative in nature, or dependent upon the chance of business or other contingencies. Essentially, the pleadings in this case leverage that the concern was for the placement of these nails and that the concern of this individual, and I think on the record today, that these nails could somehow cause damage in the future. It's all conjectural. Again, the breach and nature and scope of the breach, conjectural. It's not essentially affirmative on the record as it relates to that obligation. In addition, Your Honor, the plaintiff is not as a proper measure of damages afforded anything more than, again, the optimum perfection is not the standard. They have to establish a proven defect. A proven defect, the builder is only liable in making the work as good as specified in the contract. Pictures before this court, I think from the condition of the roof coupled with testimony.
all right, I did not want to pause this in the middle of his closing. Wait, Jedi, can you hear me? My internet.
Yeah, but here we are. We're paused.
Yeah, okay. All right. This attorney is saying, like, I know my client is shady. He just said optimum. How did he word that? Optimum performance is not the statute for a lawsuit. So whatever he said. Oh yeah.
Yeah.
So what, he didn't perform at the level that contractors should perform. What you're saying is this doesn't work. Like, dude, listen to yourself. It's
Yeah.
not the standard
As to the
to have.
functionality of the roof.
Oop.
Your Honor, the
How
roof
did I?
is,
How did I just do that? I just
I don't
played it
know. You're
without
pushing
touching the
buttons.
screen. I played it without touching the screen. But yeah, this attorney's making his money. I'm gonna tell you that.
Yeah.
He's just admitted to subpar work in his closing statement. He just admitted to subpar work.
Yeah.
solved properly. There's no information, even looking at the facts in light most favorable to the non-moving party here, be it the plaintiff, he's failed to meet his burden on at least elements 2 and 3, breach and damages. Therefore, the court's, I think, required to enter a directed verdict in favor of the defendant in this aspect of the case.
You can respond to the motion.
Your Honor, it's,
All right, this is what it should sound like. Your Honor, from what the defense counsel just said, he just admitted to his client not performing the work up to par of what is expected. Case closed. I win.
my position.
Everything that just guy said is a lie.
No, but he admitted. The
Yeah.
attorney just admitted to it.
Well, but
Yeah,
did it not pass inspection?
my client's not great.
Right. But there was an inspection, right? I mean, there had to have been. Yeah.
Oh, I don't know if there was an inspection.
I mean, it should have been.
The homeowner is a general contractor. He's just not licensed to do roofs, so he didn't do his own roof. So
Yeah.
he hired someone to do his roof.
Right.
That's how the homeowner knew that this guy fucked up. And he's just like looking, he's like, what the fuck is this? Like, you did a piss poor job and you're charging me for things that shouldn't be charged.
Yeah.
That's where this lawsuit is.
Well, and the burden though is on the plaintiff, right, to prove.
Yeah.
And
Yep.
you know.
Yep. That's where this guy fucks up.
Yeah.
Part of my strong efforts.
Oh, we're good. We're all adults here.
Homeowner, and some of it works very hard for everything that they've gotten. That I don't want to take anybody for nothing. I don't want to be taken from anybody for nothing.
Your Honor,
I
objection,
just,
stop facts and elements or facts and into evidence in order to appropriate portion.
I just wanted,
He's given some argument, so I'm gonna give him a leeway.
I just wanted my roof done properly and to the standards in which anybody else would expect. I don't think that I have done, I know for a fact that I've proven that my case, that this is not accurately done 100% properly.
How have you proven your case though? Because you're not able to give expert testimony because you're not a licensed contractor.
Correct.
You have tried to present as evidence a quote from someone who is licensed, I'm assuming. Is the person licensed?
I believe so.
No.
You believe so?
I don't have a copy of their license, but they have.
So you wouldn't got a quote from somebody you don't know their qualifications?
I called somebody who had an advertisement on Facebook on a friend's page, and
Oh, because that's
That
reputable.
right there doesn't help you either, because if you're going to make a claim that their work fell below the standard of craftsmanship, you're gonna need someone who's licensed and has a substantial professional basis to look at this work and say, this is why this is done wrong. And you're not able to produce that, is what I'm saying. You're saying just based on your own knowledge, which is not sufficient because you told me this is not your field. You told them at a deposition, this is not what you do for a living. If it was, I'm inclined to believe you probably would have done it versus paying someone else to do it. Outside of that, even if you did, you would be able to produce or provide the court with some testimony like, no, I do have experience doing this. which you've not been able to establish. You've also been shown these exhibits, which is what the roof looks like now, and you answered questions about the conditions of this roof now, which is that there's no leaks, there's been no plywood coming off, that you've not noticed or identified any shingles falling that you can identify where they came from. I'm looking at the pictures. This is supposed to be or purport to be what the roof looks like now. I don't see any missing shingles. And so your breach of contract claim, I was assuming, was because of the placement of these nails. You believe that they're not placed properly, and then them not coming back to remove the debris is what I'm assuming your breach of contract was. The debris issue, I don't think you need an expert for, but this, whether or not these were properly placed, or that the placement here essentially breaches the contract, doesn't give you the quality that you're looking for, you're not able to give your own testimony about. You need to have someone who does roofing give that testimony.
Can we recess until I have somebody come in?
When do you anticipate having someone come in?
I'll call them right now and ask them,
They'll come in today?
maybe.
Objection.
I take offense to that. I had a family member pass away overseas, and but for this trial, I could not attend that funeral.
He said he's gonna have him come today, though.
Oh,
Oh,
attorney.
snap. Now there's a dead
Seriously?
relative. Okay.
From the attorney, though, I'm not
Right.
saying it didn't happen. But he's like, I can't spend any more time in this trial. This trial is the only reason why I'm in the city today. Yeah, I mean that might be true, but if you're going to take a case and you're going to be at trial for that day, and if the judge says, okay, I'll give you an hour, then shut up, attorney. Like you've already made the
Right.
decision to be here instead of going to the funeral. If it was that close of a relative, you would have left yesterday and you would have postponed this funeral. That's all I'm going to say. Like it just come on, man. We hear that from defendants. We don't from attorneys. Though,
Yeah, from an attorney, it's like, come on, man.
this is the only reason why I'm in town right now. Like, yeah, that says a lot about.
You can't have him come today. The guy's not a licensed contractor, and when I spoke with him, said he's not showing up. He refuses to.
Oh, so you
testify.
spoke to the
I
person?
did spoke to this person in advance in preparation, when I was identified.
Is that the person you're trying to call?
I don't know who he's talking about that said they wouldn't show up. I don't know what.
Well, no, not that he wouldn't show up. The person that he's saying that he spoke to is the person you're trying to call?
I don't know.
What's the person's name?
It's, Jack DeLong.
That's who you spoke
I
to?
did.
And he told you that he wasn't a licensed contractor? Is that,
I mean.
I don't know what that is, but he said, he told you otherwise?
Yeah.
He told you he was licensed?
Yeah.
Okay, well, if you can get him in here today, within the next hour, we can take his testimony. Otherwise, I have to go into consider his motion because you are deficient in presenting your proofs.
I didn't realize I couldn't present this. I'm sorry. I had no idea. It's not being.
I recognize that.
Your Honor, that's actually not true, though, because I told him at the scope of his deposition, I asked him and I advised, you will need to present this witness in person. And he assured us he would be there. So any delay.
He's looking like he doesn't recall. Maybe you can refresh his recollection. I know I told you before from the beginning that you would have to produce your witnesses and you would have to produce your exhibits. And although he's an attorney and you're not, that doesn't mean that the court rules don't apply.
I didn't know when he would need to be here for how long.
Well, it's a trial.
Which I know.
He's got it. Wouldn't you think you're gonna present evidence if you don't present it at the trial? And we can't adjourn it because you didn't verse yourself on the rules. I told you from the beginning, you're gonna need to learn the court rules if you want to make this lawsuit. The other option that you had, which I think this was removed from small claims, is that correct?
Correct.
Is there a counterclaim that we're
Yes.
pursuing today? Okay.
It depends.
Okay,
frankly,
got it. Okay, and so you look like you did attempt to do this in small claims and it was removed from small claims. And so you could have hired an attorney, was your other option. Get someone to help you navigate this because the burden is on you. They don't have to defend it, you have to prove it. Okay, while you refresh his recollection, I'm going to go off the record so that I can review this motion and this evidence that's been presented so far.
Can I make one case point
What's that?
in regards to, even if a building is built to pass every code and inspection on the planet, there's a case in 2005, Michigan versus Ide, state of Michigan versus Ide, where the state of Michigan Works building passed every inspection you could possibly imagine, was being occupied and collapsed. So just because it passes an inspection and somebody come in and say that they believe that it might have been done correctly, that doesn't mean.
EYDE? Is what you're talking
EYDE. Yeah.
Okay, and you said that you referenced that case for what purpose? To say that,
Because
and that what happened in that case?
even if that case is the building was built to complete code and passed every Michigan inspection there was,
Correct, but
And
then
on
there
a
was
weekend-
damages because it collapsed.
it just collapsed.
I think that
and
goes
fell.
to his argument. You don't have any damages yet.
No, I have damages because I have to rectify the situation and fix it.
Well,
make it right.
that's the whole thing. You have to
No.
prove that there is a situation to be fixed.
Yeah, he didn't. Okay, so he's trying to call in this case law, which, okay, I get it, but he said previously that other than the placement of the nails, there was nothing functionally wrong with the roof. Surely it has rained at some point. So, I'm just saying.
Yeah, he quoted a lot of other things. Part of what he said is every time he goes into his attic, all of the like insulation falls like comes out of. It's like, yeah, that has nothing to do with the roof, but
Right.
it could. I mean, if he can prove that the nails are causing water damage, and so every time
Right.
you open your hatch to your attic, and that stuff comes out is due to water damage. Yeah, you could probably prove that, but he would need an expert to say that. He needed an
Well, and he
attorney.
hasn't proved it. Right.
He hasn't
He hasn't proved anything.
And I go back to the beginning. I believe him. He's done so many. I believe his story about how how many jobs he's done and his work in the construction field, and how when he looked at the roof he understood this isn't how you do a roof. I believe that. I do. But he can't prove that because he
Right.
doesn't know how to introduce evidence. And that's this
Right.
entire case is because he can't introduce evidence, and the attorney on the defense side is just bullying him.
Right.
That
Yep,
is
agreed.
this entire case in a nutshell right there. So if
Yeah.
anyone just joined, you don't have to watch, the hour and 47 minutes we've been doing this case. We still have like 15 minutes left of this.
Oh Lord.
What
rip.
is the situation? That the nails, you don't like the way the nails look? That's what the situation is, because you haven't provided us anything other than optics. You don't like the way the nails look. You believe that those nails could come out, but you've not presented any evidence to show this is what's going to happen. Or because you can't give expert testimony, you could have brought someone to say, no, because the way these were placed, it's likely that this roof is not going to last, and it's got to be fixed, and this is how much it's going to cost to fix it. Because you're not entitled. If I believe that they didn't place these nails correctly, then you wouldn't be entitled to a completely brand new roof. You're entitled to whatever the cost is to fix it. And so we don't even have that because you didn't bring the evidence for that.
I have to have the estimate, but it's not good to use.
Right. The estimate is hearsay because you need you need an expert in here to explain what this estimate was and how he came about that. Otherwise, that objection hearsay is going to come in, and for court rules, I have to grant it. And then outside of that, that person needs to explain what was wrong about this. We don't even know what was wrong from an expert's standpoint. Or if this is, from what you're telling me, if I have to look at this, I don't see anything wrong with this roof. You said it as aesthetically, there's nothing.
Aesthetically,
Yeah,
it looks
but-
fine.
Right, exactly.
It
And
looks
so the only thing that I could see from even the pictures you provided is that these nails are coming through. And I agree, that's not pretty, but that, just because I think it's not pretty doesn't mean that that wasn't, built to last or that it wasn't appropriate. I don't know that, and I needed an expert to tell me that. Okay.
Your Honor, as it pertains to whether or not
I mean, that would have made his case right there. If he would have had an expert saying,
Right.
you used the wrong nails to redo my roof, you punctured my roof through, the wood with using the wrong nails, and this is why. If he would have just had an expert,
Right.
he relied on what he knows, right? But he's not licensed, so he
Right.
can't say that. But yeah, if you go up in your attic after you just had your roof redone, and you look up and you see 1,000 nails poking through your the top of your attic, yeah, no, that's not right. It shouldn't be that way. But the way the shingles layer on each other, the water should run
Right.
off of it.
Exactly.
that
Because the nails are under,
exactly.
the shingle row above it.
Yeah. Long term, if you paid a company to do your roof and they guaranteed 10 years of the roof and they used the wrong nails and your roof only lasted 3 years, I think that's the point you take them back to court, not just because you don't like the nails, or you get an attorney right away, like this guy did not do.
Right.
But yeah, the wrong nails could potentially lower the lifespan of your roof. I understand that because you're putting
Yeah.
holes in wood that shouldn't be there. Okay, let's try to finish this up.
adjourn to have this individual attend the hearing, I hate to waste additional time, but
I'm going to review this regardless.
yeah, no doubt.
I was saying that you can refresh his recollection during
Oh,
this.
yeah, I have the testimony here pulled up to some degree that I think it relates. And I can tell the court. And I can 612 them off the record and give. I actually have a copy for him if he wants it. But
I didn't disagree with you saying that. I'm just saying that, like, I didn't know that I needed them today. I didn't know that
When
this
did
was
you
gonna
think
all
you
happen
would need
today.
them, sir?
I don't know. We've been in here 14 times.
But today's your trial.
Is it gonna all be done today? I don't know.
Absolutely.
I don't know.
We did a joint pretrial statement. We did a joint pretrial. That was rude. He passed you
Judge is getting
some
pissed.
tissue because you're in tears.
All right, defendant's crying, and no, if you use the right nails, the nails are not supposed to poke through the wood. Yeah, it might be. I'm guessing this contractor used that common practice where it doesn't matter. But yeah, your nails are not supposed to poke through the wood of your roof. They are not supposed to. That what's the word I'm looking for? That damages the integrity of the roof when that happens. Um, is it common? Yes, and that's why I said that earlier. Is every attic I've ever been in, you look up, you see nails coming through because the people that do the roof use the wrong nails. But it's not. But yeah, I'm gonna stop there. I'm not a contractor. Never worked in construction. I've seen nails through every attic of every place. And, even the houses I lived in had nails through it. But I knew that the contractors used the wrong nails. But at that time, the two houses I lived in were 30 years old. But yeah, you're supposed to use the shorter nails. And if you have to use longer nails because you're putting 3 layers of shingles on, yeah, then you need to remove it and start over.
Well, and do we
Is that
know
right?
if they were shingling over or did they rip the old shingles out? I mean, they said they were doing OSB, so I assume this was not a multiple layer.
Yeah, I don't know. I don't know if
Yeah.
they said it or not. I was just answering the question.
Yeah.
Someone said something about, you know, eh, all nails and all roofs go through. It's like, no, yeah, I mean, it's common, but it shouldn't be that
Yeah.
way. There's specific nails to put on roofs that you don't do that. All right, let's keep going. I don't know what I'm talking about, by the way. I am not a contractor. I've never worked in construction. I owned a house. I've owned 2 houses for a short period of time, and I've done a lot of work, but I've never done roofing. But both houses that I did own, had nails in the coming through the attic. So, you know, if this is common practice and I don't know what I'm talking about, I apologize. But I do know there are specific nails where that does not happen. That's all I'm going to say.
Yeah. And
That
I
was
do,
not rude.
I mean, I think they do poke through, to be honest.
Okay.
I think
All right. They're supposed to poke through.
Yeah.
Ex-
Like, not, I mean, a little bit. So,
Okay.
and Remont's got a good point there. Look up building code. Nails have to poke through and be visible so the inspector can see that you use the correct nails and the correct amount of nails.
All right. Like I said, I'm not a contractor, and like I said, is both houses that I lived in had the nails poking through. This guy is claiming that that shouldn't be what happens, and but that makes sense to me. But all right, okay, all right. I'm gonna rest my case, and I'm not gonna comment on things I don't understand anymore for the next 30 seconds.
And if we're going to become combative, I can end it
Don't
now.
need it. Not being competitive.
Okay, so here's the thing. Today was your trial. We had a whole ordeal about the I remember that, doing the joint pretrial statement because you refused to talk to them. I had to bring you guys in here. Do you remember that? Oh, that joint pretrial statement told you we were gonna have a trial and how long the trial was gonna be. It didn't say you were gonna have a 3-day trial. Why would this take 3 days? Couple hours is what I anticipate this to happen. This was supposed to be finished today. You're supposed to bring your evidence today. You were told you bring your evidence on the day of trial and that you turn over your exhibits no later than 7 days prior to trial. That was what you were told. And so no one's hiding the 8 ball from you. We told you. You didn't bring the witness. And apparently, even in your deposition, you were advised that you would need to present this witness for the court. And you still didn't bring a witness. And then it sounds like, and I don't know, that even if you did present him, sir, he's not licensed. If he's not,
That's hearsay too, though.
That's why I said I don't know.
Yeah.
If you get this guy here in the next hour and he sits there and I find out that he's not licensed, what do you think he's gonna say? He's gonna object to his ability to give that expert testimony.
All right, now I've got you guys. You guys have my mind wandering. I was supposed to let this go to Jedi, and now I can't stop thinking about it. If the nails are supposed to penetrate through the wood, the plywood,
Yep.
you know, separating the shingles in your roof.
Right.
If you replace your once you get 2 or 3 layers of shingles, you're supposed to start over. You don't want to keep just
Yeah.
piling shingles on. So
Yeah.
you completely replace your roof. So then they put a whole new roof down and put the holes back in. You're just massively putting holes in your roof over and over and over again.
Yeah, but you would
Is that-
have paper under it. So like there's a layer of I can't recall what it is. It's like a tar paper or whatever that goes under your shingles. It creates a water barrier. So it's not like just shingles on top of dry plywood.
Well, I know that. It's still all right. All right, I'm gonna
There's
stop
layers
asking.
to the onion.
There's layers. Everyone's
Yeah.
there's layers. Felt paper,
Yeah.
plywood sheeting, then the shingles. All right. All right. Again, I have no idea what I'm talking about. I'm just
And I
trying to
mean,
think of
if we want to
simple
get
business with
technical, I mean,
water.
Denali, like you're saying 3/4 of an inch, I'd argue it's 23, 30 seconds. Just saying.
I think Lone Wolf's
Damn.
right. I'm overthinking it. All right, let's finish this. Let's for heaven's sake, let's finish this video.
Because he doesn't have the appropriate experience to do that. If you want to, while I go review this, go and call and talk to this guy and find out if he's licensed. That's your case to prove, not mine. It's up to you. I'm gonna go review this evidence. So you have at least 15 minutes.
Yeah, I didn't fast forward this. She said you have 15 minutes. I think, yeah, no, I did. Look at me.
Oh, look at past you fast forwarding.
I know. But
It's so fun.
I didn't edit it out though, but at least
Nah,
I fast
you
forward.
can't be bothered to do that.
Yeah, I mean, what's this editing stuff?
Right.
I'm not a professional. I do this for
Right.
fun.
Okay, we're back on the record. In the matter of Pryor versus Zane. And, Mr. Pryor, I don't know, was it your intention to try to get your witness here
I was trying, yeah,
and you've not been successful?
not gotten an answer yet.
Okay, so today was the date and the time that was scheduled for trial. And having been properly noticed, the court was trying to grant as much leniency as possible to allow you to bring that witness, but if he's not been responsive, it is an unreasonable and undue burden and disadvantage to the other party to set this out because you didn't properly bring your witness when you were told that today was the date for the trial and you were noticed that you would need to bring any witnesses, including expert witnesses.
Thanks, Greg. I appreciate that. I really do. Those kind of comments make me feel better because I make opinions that don't make sense to anybody, but I'm glad they're appreciated though.
To trial. I've reviewed the evidence and I've reviewed the defendant's motion. And this is the issue that it boils down to. The breach of contract, again, the court's seeing or viewing the breach as twofold, or what you perceive to be the breach is twofold, I should say. You're perceiving.
Well, since you told me to hurry up, you just had a Big Mac last night. You're having a Big Mac last night and talk about a night? Yes, I just called you out, Lone Wolf.
Don't do it, man.
Don't
Taco hell, no.
no. You had a Big Mac last night. You can't do Taco Bell tonight. No, sorry,
Not
man.
allowed.
You ruined
Unhealthy.
it. You ruined it. You ruined it from the Big Mac last night. Yeah, see, he is regretting telling me that. He's right now. He's like, that was a private message. Why are you sharing this? Why are
That
you
was
doing
pause
this?
worthy.
Yeah. No. All right, let's keep going.
The placement of the nails as a breach, as well as the lack of cleanup and removing the, or replacing the eave trough, which you later stated that the eave trough wasn't a major issue for you, but provided some level of completeness for you. And so it was your responsibility because you have the burden to bring evidence to support your claim that the placement of these nails presents a breach, meaning that this is not craftsmanship that's appropriate, that these were not properly placed. I have no reason to believe that these are not appropriately placed, and that's why you would need to bring a witness that has some expertise to tell the court otherwise, because we have a licensed contractor that pulled a license to do this work. And you did cite some case law to support your position, and that's the IDE case. But that, again, is a situation where even after inspections had passed, the building collapsed. So now you see there's damage. You've not presented any damages. What I perceive is you don't like the way this looks. But based on your testimony, which is that you're not having any leaks, you're not having any missing shingles, there's no issue with the plywood. You're not showing me where this falls below the grade of the appropriate craftsmanship that was provided. So that portion of your claim, it has to be denied for no cause because you've not presented any evidence to support that. Even as I look at these pictures, everything looks to me like it's supposed to look. When I look or consider the issue as to the cleanup, I agree with your position that if you contract to have labor done, that the cleanup should be a part of that labor. However, when I look at the only thing that I have that tells me what your agreement was, which is labor only, pay, I think they're entitled to dump fees. Where did you think, or how did they discard of all of the things that came off of your roof? They should not have to eat that cost. That's a cost that should be carried by the homeowner unless you had it included in your contract.
That should be part of it. That should be part of it. When you get quoted for your roof,
Agree.
I
Yeah.
I will do your roof for $7,000. I will do it. I will do everything for $7,000. You hire me to do your roof, and then I send you like a $750 bill because it cost me that much to dispose of the old shingles. Yeah, I mean, come on, man. Hey, you gotta. Is this this guy not reading the fine print? I don't know, but that doesn't make
Right.
sense. I'm gonna give you when I bought a so I told you guys I lived in two houses. When I bought my second house, we took out all the carpet and redid it with hardwood. And it was like a 3-week process. We literally bought the house next door. And while we were so we bought the house, we purchased it, we redid all the wood, we redid all the floors. And the guy that I hired to do the floors was doing it as a side job. And he was a friend of my brother's. And he did a good job on the floor. And it was, you know, mid-range for price-wise. It wasn't super cheap, it wasn't super expensive. It was cheaper than going to like Home Depot, but it wasn't there were a couple people that could have done it cheaper, but he did a good job. Now the thing that kind of he stuck us with was all the carpet that he took up. He came back to us. He just piled it in the garage, just piled it in the garage, and the whole house was carpeted. And we redid all the floors except for the living room with hardwood. And he's like, I'm not taking that. You didn't pay me to dispose of this. So I understand this, and I fell victim to this too. But just like, why would you give me a price to do the floors and then tell me after the job's finished that you're not going to dispose of, all of the garbage that you did? Like that's sketchy to me. That's sketchy to me. Yeah, the guy still did a good job on the floors, but we had to pay. It was a lot of money because it was a whole house full of carpet we had to dispose of.
Yeah. But I mean, you either you get a dumpster, there's a dumpster fee, or if the contractor is hauling it away, they probably have a dump fee that they need to pay, right, to get it into the landfill or wherever it needs to go.
Yeah, and
Sometimes,
no,
go ahead.
sorry, go ahead. No, I was going to respond to Sherry, so go ahead, finish your point.
I don't remember.
No, he did not roll it up nicely. He cut it up. They cut it up as they were doing it, so it was in
Yeah.
shreds. So there was carpet and wood and nails mixed in, and it filled the entire garage. It was a 2-car garage, and it
Wow.
was filled with carpet. So yeah, no, we had to get a dumpster, and it filled the entire dumpster. Like when
Oh
we
yeah.
we so we scheduled this dumpster to come get it, and it was one of those giant ass dumpsters that
Hmm.
are on the back of trucks. And so we paid for it, and I thought we were going to be able to throw all this because we were moving houses. Like I said, it was right next door. We didn't have to even get a moving truck. We literally just walked through the grass to the next door, and we thought that we are going to have so much room in this dumpster to throw all this stuff away. No, the carpet was filled the dumpster, and they wouldn't let us put anything else in it.
Mm,
But I
yeah.
mean, like I said, we saved like $2,000 on the flooring from going to like a chain, but then we
Right.
ended up spending $1,500 on a dumpster and getting rid of all the carpet. So we didn't
Right.
save any.
Right.
The
Yeah. I
quality
mean,
of work was good.
there's costs. Like
Yeah.
it's if it's not the cost up front, it's the cost somewhere else.
Yep. Yep. All right. Anyways, let's finish. We are actually at the end of this video, so let's finish this up.
Okay, let's do it.
Contract, which this was for labor only, dump fees would not be included, that's your responsibility. That then leaves us with $1,000 that you never paid, correct? Is that it? Yes?
Correct, yes.
Okay, and so I don't value a cleanup, at least based on what I'm looking at, to cost $1,000. So if I consider that, they are actually at a loss, not you, because they didn't get the $1,000 plus the $397, which means that they're still in the whole $1,397.60. And you did have to clean it up yourself, but you didn't have to pay the remaining balance. Again, I don't see that there's been any issue with the craftsmanship, workmanship that you presented, and you don't have a witness or any other evidence that could be properly submitted to the court to dispute that this is not appropriate. So because of that, I have to find a no cause of action, meaning in favor of the defense. There's no cause of action, so you will not get any recovery based on what you're seeking. You did originally file a counterclaim. I don't know if it's your intention to still move forward with that.
I don't want to withdraw without prejudice that counterclaim this time.
Okay, the counterclaim is withdrawn, and can I get an order from you?
Sure. No cause.
And withdrawn the counterclaim without prejudice.
I'll get one presented probably tomorrow morning, if that's okay.
Thank you, and then I want to return everybody's exhibit.
All right. Speaking of the commission free, Sparkle Poots, thank you so much for the PayPal. I appreciate it. Yeah, I do need to take better care of myself. I got a very stern lecture from Heather. For those of you who weren't here earlier, they heard this. I was working out today. I was doing a little jog in the park. Jen Hardy asked me to ask a couple of questions for her interview with Judge Boyd tomorrow night. So I went to the park. I did a little jog. I was running around. I was there for about an hour and a half. They have this thing in the middle of this park called the Tree House, and it's probably it's probably like 300 or 400 feet in the air, and it overlooks the entire park. It's just like this overlook kind of thing. And I went up there and I took this video and I asked questions to Judge Boyd at this spot. Went down, and then I was just walking back to my car. And right when I got in front of like the main office building, my legs just completely cramped up and I felt this like sharp pain through my legs, and I just sat down. I didn't pass out, but I had to sit down. But one of the people in the office saw me, and they came out and they were talking to me, and they're just asking me if I was okay. I'm like, yeah, I'm fine, I'll be okay. And there's like, you got to come inside and drink some water. I'm like, yeah, like I'll be okay. Like I live 2 blocks away from here. Like it literally is right next door to my house, like or my apartment. And so they begged me to go drink some water. So after about sitting there for a couple minutes, I got up and I went to the office and drank some water, and they called an ambulance. Like, no, it's like I'm okay. Like my legs cramped up. Like I'm fine. I've been an athlete my entire life. I know what cramps feel like. I'm cramped. I'm dehydrated. You guys gave me water. I'm good. And then I went home, but I've been struggling since. So yeah, that's what I said a little earlier. Heather was freaking out about it. Of course she would, but yeah,
Of
that's
course
why
you would.
I brought Jedi up here tonight, because I was about an hour ago. I was really struggling. I thought I was gonna fall asleep. My head is pounding, but I'm okay. I'm okay. It was just it was a hot day. Didn't eat enough this morning. Didn't hydrate enough before I decided to go for my jog, and I paid for it. So it's what happens when you're in your 40s and you still think you're 20. So
Oh, that's fun that you're 40 and you're like, oh, when you're in your 40s.
yeah, I am in my 40s.
Well, you're 40 on the nose. So
No, no, no. But yeah, it's fine. I'm okay. I'm okay.
yes.
It was just my
Just
legs
gotta
literally
hydrate.
cramped up. My legs literally cramped up, and I sat down and I scared some people, because it was, I guess in my mind I sat down, but in their mind I just collapsed, I guess. But I didn't lose consciousness. That's why when they're like, you passed
Yeah,
out, like, no, I didn't. Like I didn't hit my head. I was
right.
literally I felt my legs cramping, and I just kind of like laid down as pleasantly as I possibly could, I guess. I don't know. To me, I didn't collapse. I didn't fall over.
Yeah.
To me, I just kind of laid down. But I,
You
the
just,
people that,
you found the ground in a very efficient and quick manner.
yes, yes. But I scared the people at the park, and
I'm
they called an
sure.
ambulance. But the
Well,
ambulance,
they're
they
just looking
talked to
out
me.
for you.
Yeah, they talked to me, and everything's fine. Everything's fine. Like I said, my legs just cramped up for a
Yeah.
second, and I just kind of fell down. But
Yeah.
it's it was a lesson that I need to eat a little bit more before I work out, and I need to hydrate before I work out because
Yes.
it was like 93 degrees with 100% humidity. Not that, and it was 2 o'clock in the afternoon when I generally when I do my workouts, it's 8 a.m. So I wake up in the morning, I do my morning routine with Heather. We drink our coffee together, and that's when I do my workouts. And then when I get back, I'll make my video for the morning. But this morning, my schedule was just off, and I didn't do it. And so I did my workout in the middle of the afternoon.
Yeah. And it's, that's when it's hottest.
Yeah, yeah. It's just
So,
it affected me. It affected me a little different that I was not aware of.
yeah. Yep, for sure.
But I'm okay. And Jedi, thank you so much for coming and
You bet, man.
co-piloting this for me with me.
Anytime.
All right, let's finish this. You ready to let it play out, Jedi?
I am ready.
All right. Yeah, well, we're gonna let this play out. There's about 3 minutes left. I'm not gonna pause it again. I think we all know what's going on here. Everyone's leaving anyways. There were 300 people here an hour ago, and now there's 125. Like everyone's like, yeah, we know what's going on in this case. All right. You guys are awesome. Thank you for hanging out. Jedi, again, thank you for being a co-pilot. And everybody who was here, I hope you hit that like button. Thank you for the super chats. Thank you for the gifted memberships. Thank you for the membership milestones. All right,
Yeah.
we will see you tomorrow. I will jump in Discord for about 5 minutes, but that's about it. I feel like because I just said what I just said, people are gonna want to make sure
Want to
I'm
kick
okay.
you out and make you go to sleep?
Yeah. So I will jump in Discord for a few minutes after this, but I'm not gonna be there long. So Jedi, you're
Yes,
off.
sir. Thank you. So are you.
Yay, thanks.
Yay.
All right. Until next time. Bye.
Your Honor, I would just say for the record that we did do a offer of judgment in advance with the no cause finding. We're going to reserve, or at least preserve the option to file a motion for attorney's fees. On this case, I just would love to record reflect that. I'm not presenting the motion at this time. I'll just show in the written form if so appropriate, seeking the return of attorney's fees wasted at trial.
Thank you. Okay, that is noted for the record. And Mr. Dane, if you could get these exhibits.
Yeah, I approach, thank you.
Yes, please. And these are the plaintiffs on the right and then yours are on the left. And that's for the court record. And that concludes today. Any additional matters for today's record?
From defense, Your Honor, I think free time.
Any questions, sir? I'm assuming that's enough. Okay, you're all set.
Actually, I do have one question. So is like. So it's both cases are dismissed.
He's withdrawn his counterclaim against you. That's without prejudice, meaning we didn't litigate it, so he does have the right to still bring that as a separate case and serve you with the lawsuit, is what he's saying. And that he has the right to do that because it wasn't litigated and decided on. And then he's also saying that there's the potential that he can file under the court rule for attorney's fees because there was a no cause. So if that's happened, if he files for that, you'll also be served for that, and then we'll have a hearing for that.
What else?
I'm I'm not advising you on what you're supposed to do. I'm just explaining what he was saying.
Thank you.
You're welcome.